Hello, my name is Alan Weiss. This video is to help you avoid going emotionally and financially broke. My proposition is simple. Separation or divorce can be simple if you remove any irrational thoughts that you have against your spouse or your partner and you are prepared to negotiate your position. I've spent 11 years working with many of Australia's top legal practitioners. I've also spent hundreds of hours visiting the courts and watching stupid fights between two people that once thought that they would spend the rest of their lives together. And that is the sadness of the whole thing. You can negotiate and settle your differences, or you can apply to the court to make decisions on how the assets will be divided. Such approach, in some cases, may be unavoidable. But going to court puts you into an adversarial position. You need to leave the door open for negotiations. Going to court is expensive and the return on the investment is difficult to justify. While I understand that you want the best outcome, I believe you should focus on the ways to reduce pain for all parties involved, especially where children are involved, and keep legal bills to a minimum. Your lawyer will encourage you and advise you on the best way to mediate your position before applying to the court. What do you call this process? Mediation? Collaboration? The reality is that you are talking about negotiations. Negotiations is not a winner-take-all scenario. There isn't such thing. It is more a process that allows you and the other party or your partner to address the common problem from the standpoint that each would negotiate the best solution for themselves, without necessarily meaning that the other side will lose everything. This is what is often referred to as a win-win result. The biggest question is how much of the property is yours? What are you actually fighting for? Suffice to say that for most people the financial circumstances will change dramatically. I'm saying it with hurt and understanding. It is almost most likely that the family home will be sold and each party will need to either rent or buy a smaller home. I feel it is important that you understand and conceive the new scenario from the start. I also want to share with you the basics of how property division works, how I understand it works. Now, the law tells judges what things they need to consider when they determine a property settlement application. In simple terms, the court has to go through a 4-step process. So the step number 1 is define how big the pie is, what you're actually fighting for. The aim here is to establish a net asset pool that is to be divided between you and your partner. To make things even more simpler, let's start with the family home, which is usually the biggest asset. Agree on its value. Apply the same to any other properties that you or your partner own. If you cannot agree on the estimate value, I suggest that you agree to have 3 agents to appraise the property. The average estimate is what seems as a reasonable value that you should consider and agree on. But if you cannot agree, then the court will appoint an expert witness, a registered valuer, to value their assets, and that is expensive. The other thing is to list all other non-assets, non-real estate assets that have any value, such as money in the bank or shares, furniture, and so on. The other assets that your lawyer would argue are known as add-back. Now, for example, money paid on legal fees, money that is recklessly spent or paid to a friend or relative. Next is you need to list all your liabilities which are under your name or your partner's name or your spouse's name. For example, mortgages, personal loans, car loans, credit card, tax liabilities, or any other liabilities. Try to agree on the value of it, of the actual debt. Step number 2 is assessing the contributions. The court will consider both financial and a non-financial contribution that you and your partner made to the relationship or marriage. Few examples of financial contributions are money or assets brought into the relationship. That is from the beginning. It could be a gift or inheritance that you receive before or during the relationship. Payout and wages. Few examples of non-financial contributions are taking care of the children and the homemaker, which is looking after the family home, or even undertaking renovations. Step number 3 is identifying future needs of yourself and your partner. For example, taking care of small children, earning capacity, health issues. The 4th step is whether the proposed property settlement is just and equitable. Is it fair? A court has considerable discretion when carrying out step 2 and 3. This means that in any matter there will be a range of possible outcomes that will be considered to be fair or just and equitable, and one particular judge's view may differ slightly from that of another. There are no mathematical formulas for working out what the results will be, and because of this, it is impossible for anyone to predict with an absolute accuracy what the outcome of such proceedings will be. When lawyers give advice what a person's entitlement will be, well, they are basing it on the information that is provided to them. They are also basing it on their knowledge, on previous decisions, in previous cases. Even with such knowledge, all that can really be given is an estimate, which is a range of possible outcomes. This is why you need to think about every decision that you make. It is a commercial decision. The Aussie Divorce ebook explains to you some of the basic principles of property settlement decisions. For more information about family law or any topic within family law, view aussiedivorce.com.au. We have almost 2,000 pages of information available. For Ask a Question, it is free to ask. You simply fill up the form, submit it to us, and one of our family lawyers will get back to you. My name is Alan Weiss.